Hello, my name is Adam Alley, and this is my presentation for CPSC 313, the Computer Impact. And my section covered was, Can Online Piracy Be Stopped by Laws? This section was written by Pamela Samuelson and appears in our annual editions, Technologies, Social Media, and Society, edited by Carolyn Schaefer Westerhof textbook. It's Unit 5.5 and is on pages 87 through 89. So what is the issue here? The issue here is online piracy. And that's somewhat defined as illegal sharing of multimedia intellectual property on the internet. This involves the hosting, uploading, or downloading of this intellectual property. More specifically, the online piracy is dealing with copyright infringement, and this could be audio files, usually music, video, movies such as movies, television, other broadcasts, publications such as books, maybe textbooks, comic books, and entertainment such as video games. Why is online piracy an issue? Well, the entertainment industry loses great sums of money due to the decreased sales that result from illegal sharing of their intellectual property. Weak enforcement of intellectual property rights, IPRs, outside of the U.S. resulted in entertainment industry urging Congress to adopt anti-piracy legislation. So what can be a solution to resolve online piracy? One of those pieces of anti-piracy legislation that was urged upon Congress by the entertainment industry was the Stop Online Piracy Act, also known as SOPA. SOPA was a piece of legislation that would have given the entertainment industry new legal tools to impede access to foreign, quote-unquote, rogue websites. Receiving strong opposition from technology companies, computer security experts, civil liberties groups, and members of the public, SOPA did not pass. What's important to remember is that this article was written in 2012, so that was 5 years ago. The article concluded that SOPA would be unlikely to be enacted in anything like its original form due to its many flaws. And the article focuses primarily on those flaws. Blocking access to foreign rogue websites through SOPA would have empowered the U.S. Attorney General to seek court orders requiring foreign rogue websites to stop providing access to infringing copies of U.S. works. It further empowered the U.S. Attorney General to serve these orders to U.S. Internet intermediaries, including Internet Service Providers, ISPs. Now, the reason is the rogue websites who were sharing this pirated media were unlikely to comply with court orders, especially because most of them were foreign. They were not U.S. websites. So that's why the Attorney General was empowered to serve these orders to the ISPs who do reside in the U.S. And these would have required these companies to take technically feasible and reasonable measures to block users from accessing their foreign websites. SOPA detailed these feasible and reasonable measures, and they were not so feasible nor reasonable. So upon receiving a copy of a rogue website order, search engines would have been required to block access to the sites through domain name systems locking, DNS blocking. Additionally, payment providers such as Visa or MasterCard would have had to suspend services for completing transactions through these websites, and advertising services would have had to discontinue serving ads and providing or receiving funds for advertising at these sites. Those who failed to comply with the DNS blocking obligations could expect to be sued by the Attorney General. Furthermore, the Attorney General could sue those who provided services designed to circumvent DNS blocking. This could be done through plugins, browser add-ons, or directories that were workarounds to DNS blocking. They could also be sued by the Attorney General. So challenging the U.S.-directed websites. SOPA would have given holders of U.S. IPRs the power to challenge U.S.-directed sites dedicated to the theft of property. So firms who believe themselves to be harmed by one of these sites could have sent letters of payment to payment providers or advertising services and demand that they cease working with these websites. Payment providers and internet advertising services were then tasked with notifying the challenged sites about the dedicated to theft allegations against them. The content owners could also sue those who failed to comply with demands if they cease dealing with these challenged websites. So in other words, the content owner could not only sue directly the dedicated to theft sites, but they could also try to sue Visa, MasterCard, or any kind of advertising agencies who worked with those websites. SOPA had many flaws. Problems associated with DNS blocking. It would undermine the security and stability of the internet as a platform from communication and commerce. So fundamentally, SOPA was inconsistent with DNS security extensions, and these were developed to avoid abusive redirections of internet traffic, usually by criminals, autocratic governments, or other wrongdoers. The DNS SEC website operators would have either had to abandon the DNS SEC or be in violation of issued court orders. So the idea is to keep the internet a free, open environment. DNS SEC exists for that reason. This SOPA legislation would have tried to put a stop to that kind of free access through the internet. And also it would be ineffective. It's impossible to bar access to alternative DNS servers around the world because there are literally millions of them and new ones pop up all the time. And circumvention of DNS blocking is simple and available, which is what I talked about earlier about the plugins, add-ons, and other ways to circumvent DNS blocking. It's too simple to get around it. Problems associated with the dedicated to theft provisions were that the wording was too imprecise. The book asks, what does it mean for an intermediary to take deliberate actions to avoid confirming a high probability of infringement on a site? So infringing clips that were found on YouTube, one user uploads them, something that they don't own the copyright for. Does YouTube become deemed a dedicated to theft website? Another example is if one person is selling the illegally acquired MP3s or illegally sold MP3s on eBay, does the entire site of eBay become a dedicated to theft website? This also represented a dramatic change in the rules of the road affecting internet intermediaries. Companies considered the dedicated to theft definition to be fundamentally inconsistent with the safe harbors established by the DMCA, Digital Millennium Copyright Act. Under the DMCA, internet intermediaries have no obligation to monitor their sites for infringement. Safe harbors established by the DMCA have been an important factor in the extraordinary growth of the internet economy. SOPA would have impaired this relationship. SOPA's failure. The author of the text says that such a law might have passed had the entertainment industry sought more narrowly targeted rules aimed at inducing payment providers and internet advertising services to stop the flow of funds to sites known to be truly dedicated to infringement. Examples were Napster, Aimster, and Grokster, who some of you might remember from years ago. Ultimately, the collapse of support was principally due to concerted efforts by ISPs, security experts, civil society groups, and millions of internet users who contacted their congressional representatives to voice opposition to the bill. So it did not pass. It was a failed attempt. So what are future issues related to online piracy? The text talks about the battle of internet intermediary liability for infringing acts of users to continue. Again, this was written 5 years ago, and these are issues that you can constantly see if you follow this kind of news. The text also suggests that entertainment industry will make further efforts to place greater legal responsibilities on internet intermediaries. And again, you can read about this all the time if you follow this kind of news. So when asked what's a solution to this problem of internet piracy, I talked about SOPA, but SOPA was a failed solution. It was not a good one. So though this is not in the text, something that I see that has happened in the past 5 years that could have been possibly a solution to this problem is the introduction to so many streaming services. For music, there's Spotify and Google Play. For video, there's services such as Netflix, Hulu, and Amazon Prime. This gives internet users more direct access to the content they want, but it still provides the internet entertainment industry with some sort of funding. It's not as much as they would have gotten if people had to buy the DVDs, had to buy the CDs, but at least they're getting some money as opposed to piracy, which affords them no money. So I think that would have been a better solution, and it's possibly something that arose from this same problem during this same time, which again was 5 years ago. That's the conclusion of my presentation. I hope you find it helpful. Thank you for watching.